financial problems, elder law, tax problems, business matters, divorce, personal injury, bankruptcy, your life, your reality. Life is complicated. There is the law and there is reality. Welcome to Law and Reality, sponsored by Thav Gross. Now here's your host, Ken Gross.
Hi, welcome to this segment of Law and Reality. Today's segment, we're going to talk about slamming the debt collector issues, and when bankruptcy is the best solution to solving a tax problem. Two different subjects. We have back with us in the studio today Ian Linklip from Linklip and Associates. He's our consumer law advocate and specialist with respect to going after debt collectors, robo-dialing, background checks, these kind of issues. We had him with us last week. He takes on the credit agencies. We've written terrific information from him. This week I want to talk with Ian about credit reporting errors and background checks. Before we do that, I want to say good morning to everybody. Good morning, Jenny.
Morning, Ken.
Good morning, David.
Always a pleasure.
Ian, welcome back.
Thanks for having me.
All right, so let's dig right into it because these are issues that everybody experiences. Credit reporting errors. I'm telling you, there's stats out there. I looked it up and I saw it in your materials, in your website, but I went online and saw that 60 Minutes reported there are 40 million mistakes on American credit reports. The FTC suggested 24% of reports contain errors. The most startling report estimates 79% of credit reports contain at least one error. You agree with that?
Is that consistent with what you see? 79%?
It's absolutely consistent because if you think about the way that those numbers shake out, okay, there are three major credit reporting agencies, and there's probably hundreds of other small ones, but the major ones, Experian, Equifax, and TransUnion, they can be used by any of the creditors, and if you're going for a mortgage, all three of those will be used. So if there's an error, if you've got even at the low end, a 20% chance of having an error in one of those reports, you got three reports. Most of the time when I'm sitting across the desk from somebody, there's going to be an error someplace in those reports, and because they've got three reports, there's three chances that one of those agencies or the people reporting to them are going to make a mistake. So there's no question, it comports with my experience that we see lots of errors. Pretty much everybody who walks into my office and sits down across from me at the desk, we're going to find that there's a problem in the report.
What kind of errors can you solve, and which ones are the ones that you can actually go after the collection? Who do you go after to recover damages? What do you solve, and where can you recover damages sometimes?
Well, let's clarify for a minute what we mean by solving, because there's two kinds of resolutions that you can get. You can get the self-help resolution, or you can get the litigation resolution. And by that, what I mean is that the statute itself, the Fair Credit Reporting Act, gives consumers a remedy, something they can exercise on their own to try and resolve problems with the report. And the remedy that the statute allows is you can write a dispute letter to the credit reporting agency. And when you write that letter, that will trigger an investigation process. They're required to conduct a reasonable investigation. And if that information that they're reporting that's got a problem has come from somebody who's provided data to the Bureau, in other words, the Bureau has not gotten the data itself, then they're required to send a notice to that company, and they have to do a reasonable investigation
to the
as
creditor.
well. To the creditor, to the bank, to the debt collector, whoever's reporting that data, they're going to have to do a reasonable investigation as well. Sometimes that process will result in a removal of the item. The most successful of those is usually in cases involving identity theft. The bureaus have gotten a lot better about resolving identity theft issues, especially if there's an identity theft affidavit or a police report that's accompanying that, because there's specific regulations that talk about how it is that they have to handle those disputes. Now, if the consumer cannot solve that problem on their own with a dispute letter, if they can't resolve it with an attorney's help in the dispute letter, then we have to go into a litigation situation. And once you enter into litigation, we are looking to recover damages for the consumer for failure to do the reinvestigation, failure to actually get the report corrected.
do you find situations where you're going after one debt collector that is a repeat offender, so to speak, that it's not just one person that's been victimized, they've victimized hundreds of people? Can these things turn into class actions and things like that, or mass or mass claims where you have more than one plaintiff?
Well, in theory, they can. We don't see these kinds of cases becoming class and mass actions quite so often because there's a lot of individual issues in these cases, and they may not necessarily be suitable in those cases. But we do see the same companies time and time again causing the same problems because, in reality, today's market, big banks are dominating the marketplace. They are the largest data providers. The largest of the large banks, the 10 largest banks, are providing the vast bulk of data in the country. And so, we see that. And the same thing's true in the debt collection field, that the same debt collectors are receiving most of the debts on the, the first instance.
I have a mistake in my credit report.
Sure.
I find out and I see it. I send a letter in 30 days, nothing happens. What do I do? Do I call you? And do I say, can you help me resolve the problem? And what if it's damaging me? I can't get a car loan, or I can't get my mortgage approved. Can I recover damages if I lose the house I wanted to buy because there was inaccurate information reported onto my credit report?
Yeah, absolutely, you can. But usually, we look at these things and we say, we try and figure out first whether or not a dispute has been written to the Bureau and whether it's a good dispute. So if people are thinking, I was denied a house, I was denied a car, I was denied a job because of my credit report, the first question that we ask every time is, have you written a dispute letter to the credit reporting agencies? Because the reality is you're unlikely to win a case against the credit reporting agencies unless they have been on notice in some way that there's a problem.
So you need a good dispute letter as a beginning start.
Is there a time period that you have in which to give that letter?
No, you can write that dispute letter at any time.
So if somebody comes into you 6 months later, 3 months later, a year later, if they've got a legitimate dispute, you can then invoke that process.
Absolutely, and regularly, with identity theft cases or what we would call a mixed file, it may take a while to do an investigation and gather the necessary documents to write a good, solid dispute letter that's well documented.
All right, so that we've got that issue, and then I want to come back after the break. I want to talk about background checks.
Great.
Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
Worth Ave Gross, our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Thav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Thav Gross today, 888-235-HELP. It's devastating, the effects of debt and foreclosure on you and your family. There is a solution.
Worth Ave Gross, our firm will solve your problem. Some fear the word bankruptcy, but in reality, it's a strategy to save your home and to eliminate debt. If you're in financial trouble, timing is critical. You need to take action now. We've been saving homes and eliminating debt for over 33 years.
Call Thav Gross, 888-235-HELP.
A lifetime of hard work. If you don't have the right plan in place, you can lose your home, your savings, and more. And you didn't come this far to lose everything. Samasco Law wants you to know that laws are changing. Today, the average cost of nursing home care is $85,000 a year. With proper planning, we can help protect your life savings and get you the Medicaid and nursing home benefits you deserve.
How much can you afford to lose? Call Samasco Law today.
Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP. If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Thav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke.
You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
Worth Ave Gross. Our firm will solve your problem.
All right, welcome back. All right, so Ian, another area that I know you get involved with that causes a lot of chaos out there are background checks. What's the situation with a background check, and where is that in an employment context where someone is applying for a job and all of a sudden the employer has a background check on them and then they come back and say, sorry, no soup for you, no job?
No soup, no job, exactly. Well, let's start with this. Background checks have become, incredibly popular amongst employers. Employers, the data that is out there has become so cheap and so easy to get that every employer thinks about doing a background check before they hire somebody, and most employment attorneys are telling their employer clients, hey, get a background check on everybody before you let them in the door because you don't want to be responsible if there's a problem later.
Which premise is okay, I would imagine.
Well, the premise is okay. You want to know who you're dealing with, but the problem is this. Any employer who is using a background check is subject to the Fair Credit Reporting Act, and that statute has really important protections for consumers because at the time that this statute was passed, 30 years ago, even back then there were enormous amounts of problems with the credit reporting agencies using old, antiquated data. Things where convictions had been overturned or withdrawn or expunged. That was happening 30 years ago, and it's still happening today. And the technology that we've got and the availability of data has only made that problem worse because now it's being distributed to everybody. So when an employer...
So if I'm an employer and I'm doing background checks, I have to be extremely careful, otherwise I can get into trouble.
Absolutely. You can be sued if you are misusing these reports. So you have to make sure that before you put your hands on a credit report or a background check and use that to evaluate somebody, you know exactly how to comply with the statute. So on the consumer side of this equation, before an employer can pull a report, they have to ask you for and you have to give consent for that. You have the right to say, no, I don't want you to pull a background report. They may tell you, no, we're not going to employ you.
No job for you.
Yeah, no job for you, but they have to get your consent. They also have to give you a notice of your rights, and it's got to be a standalone notice so that you know exactly what's happening and what your statutory remedies are going to be. Now, if the report comes back and there's bad data on it, and by bad I mean adverse, it says you're a criminal, you've had a conviction, something is wrong with you that would suggest you shouldn't be hired, before the employer can say to you, no soup for you, they have to say to you, we're thinking about not hiring you or not promoting you or not giving you the pay raise or the security clearance, whatever it is. They have to give you an advance warning, and they got to give you a copy of the report so that you can look at it and figure out whether or not it's accurate.
What if the employer is not even relying on that report, and there's another reason? Is that a scenario where the employer could proceed, or if they've acquired the physical report, do they have to give you the notice?
I would tell you that if you're an employer and you got the report, you want to give the notice because the standard is
cross your T's and dot your I's.
Yeah, exactly. Because the standard on the statute is if you've relied on the report in whole or in part. So once you touch that report,
I never looked at the report.
There's going to be a reasonable inference that you've relied on it in some way or another. So getting back to the consumer side of this equation, once you've got that report in hand, the employer cannot use that information right away. They have to give you a reasonable amount of time to correct the report or to explain problems with it. And so if you
explain away the problem and they still don't want to hire you, then is there an issue? Has the employer protected himself at that point, or is it still a debate as to whether the employer didn't believe the correction to the report?
Well, the employer can believe or not believe the report, but the employer is not done with his compliance yet. The employer still has to give you what's called an adverse action notice, which is a written notice saying, we've decided not to hire you based in whole or in part on the report, and they've got to give you the identity of the report, and they've got to give you a notice of rights again.
So is it a fair statement to say if you are in an employment scenario and you did not get the position or the promotion as a result of a background check and you want to investigate it, would be something to talk to you about?
Yeah, absolutely. And one of the other things, the other protections that's in place is, and this is less well known because It's, most of the interaction between the consumer is with the employer, the prospective employer. But there's another standard that's out there for the credit reporting agencies that are issuing these background checks. The background check companies themselves have got to make sure that either A, they have engaged in what they call strict procedures to ensure that the data is accurate, or they've got to give you a copy of the report before they issue it to the employer.
So you can go after them as well?
Yes.
So I kind of want to wrap up if we can on that. If you have that issue, there's a link on our website to reach Ian on debt collectors. Go to lawandreality.com or thavgross.com. Click on that, fill it out, and then someone from Ian's office will get back with you to help you on that issue. If you had a quick point, David, go for it.
Let me make one. If you're
Yeah.
somebody who's had an expungement or you've been diverted under HIDA and you've had your conviction removed from your record, there's a good chance that it may still be on one or more of your background reports, and you may be denied employment. And if that's happened, that's one of those situations where you definitely are going to need the help of an attorney.
And I just wanted to ask you real quickly, do you typically see that the big employers that have their own HR departments and are staffed well are incompliant, and therefore it may be the mid-sized, less labor-intensive that don't comply?
We have seen people in our office from across the whole end of the spectrum. The largest employers are still not fully compliant with the Fair Credit Reporting Act, and most of the smaller employers, if they haven't hired an HR attorney to help them through this process, they certainly have they're going to have a lot of challenges in making sure they're getting themselves in line with the statute.
Sounds like a lot of potential claims there, and people need to know you've got remedies and to look out and to pursue them. We're coming up to the break, Jenny. When we get back, I want to talk some taxes. Tax deadline is April 18th this year, and I want to talk about what do you do if you can't make it with an offer in compromise. We'll be back.
Is the debt piling up? Struggling to get by?
It's all about preserving future income. Bankruptcy is one option. When it's right, it's the least costly, most effective way to save your home, eliminate a second mortgage, and wipe out credit card debt. But you need to address the problem now.
We help people with bankruptcy. Call the experts.
We're Thav Gross. Our firm will solve your problem.
888-235-HELP. That's 888-235-HELP. Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
We're Thav Gross. Our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Thav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Thav Gross today, 888-235-HELP.
A lifetime of hard work. If you're approaching retirement and don't have the right plan in place, you can lose your home, your investments, and your savings. And you didn't come this far to lose everything. Putting a solid strategy in place with Samasco Law legally protects your assets as well as your wishes. Since a will doesn't cover you medically or financially, Samasco Law goes beyond ordinary asset management protection to safeguard everything you have.
How much can you afford to lose? Call Samasco Law today.
If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Thav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
We're Thav Gross. Our firm will solve your problem.
Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP. It's devastating, the effects of debt and foreclosure on you and your family. There is a solution.
We're Thav Gross. Our firm will solve your problem.
Some fear the word bankruptcy, but in reality, it's a strategy to save your home and to eliminate debt. If you're in financial trouble, timing is critical. You need to take action now. We've been saving homes and eliminating debt for over 33 years.
Call Fav Gross 888-235-HELP.
All right, welcome back. All right, let me do announcements, and then Jenny, I want to go over to you because last week we talked about the offer and compromise doesn't always work. We need a solution for the problem that has a big tax liability, but they can't do an offer and compromise. All right, we have a seminar coming up on Wednesday, April 13th from 6:30 to 8 o'clock p.m. at our offices. It's called Go Away, Mr. Debtman. David, please don't look at me anymore. It's focusing on how to preserve future income for you and your family. The whole concept that we work with is the idea of if you can eliminate your debt, you can then take that $500 to $1,500 a month every month that you're paying to the credit card companies, and instead of paying it to them and getting nothing over the long run, you put it into the bank, into a tax-deferred IRA or into a 401k, so that in 20 years, with the benefit of interest and hopefully the stock market creeping up over time, you'll have a good, solid retirement. If you're paying $500 to $1,500 a month on your credit cards, you have the power to assure yourself of a retirement. All you have to do is take the steps so that you don't have to pay that money to them and instead pay it to yourself in the form of your savings account.
Ken,
that's what the seminar is about.
It's also important to note that the seminar is in a relaxed atmosphere, and it's content. You're going to find out how things work, what we do, and we stick around for as long as it takes to take questions and answers and whatnot. It's absolutely no hassle, no charge. Just listen and get good information. That's
Not
all
only
we
that,
ask.
you get a free copy of my book. Don't forget.
Well, yeah, I guess there's always a detriment.
And cookies.
And you get cookies and water. But then there's no fancy meals, so don't come for the meal. If you want the meal, go to the financial advisor. Listen to our radio show noon to 1 p.m. WCHB 1200 AM 99.9 FM with Mildred Gaddis. Saturdays WDFN 9 to 10 a.m. 11:30 a.m. I want to go back to Jenny and thank our sponsors, Stav Gross and Samasco Law as well. So Jenny, last week we talked about the offer and compromise, and we kind of concluded with the idea that if you've got too many assets, like money in your IRA or 401k, you cannot qualify for an offer and compromise. So the question is, how do we solve that problem?
Well, during that meeting, as I said, where we're determining whether you qualify for an offer, the next thing we would look at is what type of installment agreement you would qualify for, or whether you would qualify to be uncollectible, meaning the IRS does not remove the liability but agrees you can't make a payment for a couple years.
Suppose I got $300,000 in my IRA.
It's highly unlikely that they would deem that you're uncollectible. However, if we set up a payment plan that was going to pay it in full before the statute expires, they may not require you to remove funds from your IRA. That may be a Chapter 13 scenario, or we may look to see if you qualify for a Chapter 7.
Now, here's something that's very interesting. People don't realize that income tax liabilities, not payroll taxes, when you're an employer and your company goes out of business and you haven't paid the payroll taxes on your employees, that's not dischargeable in bankruptcy. But income taxes are dischargeable in bankruptcy, and there's a three-prong rule. It's called the 3-year, 2-year, 240 rule. The taxes, it has to be more than 3 years since the tax became due. It has to be more than 2 years since you actually filed your return. You can't let the government do a substitute for a return. You have to sign your return and file it the old-fashioned way. And it has to be more than 240 days since the tax was assessed, which is almost always the case. If you meet those three prongs, generally speaking, the tax liability is dischargeable. So in our case, if you had 2012 taxes, they became due on April 15th, 2013, 3 years would be April 15th, 2016. Those taxes and anything prior to that, if you filed your returns more than 2 years ago, would be dischargeable.
If you qualify for a Chapter 7.
If you qualify. Now, sometimes you don't qualify for 7. If you've got $200,000, I'll come to you in a second, Dave, $200,000 of equity in your home, you're not going to be able to protect that equity. But if you've got $300,000 in an IRA, you can qualify because the IRA and the 401k is exempt from bankruptcy.
I need to emphasize, though, and it's amazing that income taxes are dischargeable because not most, but a significant percentage of the bankruptcy attorneys don't even understand that. However, this 3 years, 2 years, 240-day rule you really need to understand the rule, because there's certain things that we see, Jenny and I and yourself see all the time. And Brian, where those time periods may be extended because of pending offering compromises, pending negotiations, or things of that nature. So you need to know when you're in the money, when it's time to file. We've had clients come in, literally, if they would have waited a day or a week, could have discharged hundreds of thousands of dollars of taxes. So absolute malpractice for filing too soon.
It's a big issue. Brian always says, and I think he's out from Florida at the moment, but Brian usually always says most of the bankruptcy attorneys call him to get the right advice as to how you go about discharging the taxes in bankruptcy, because it is an intricate rule. But the biggest thing for people to realize is it's another tool that we have to get rid of the debt, and it works better than an offer in compromise in this way. In offer in compromise, even when you get it approved, there's a rule that says you have to stay clean for 5 years, which means you have to file your taxes on time and pay all your tax liabilities. Yeah, it's not so easy. The person who gets into tax debt has a tendency to be a repeat offender sometimes. So that's a consideration that we often worry about. Whereas if you file bankruptcy and you qualify, you're home free on it. And the other factor is this: if you have too much income, Jenny said, what if you qualify for a Chapter 7? Generally speaking, if you have too much income, let's just take a broad stroke number. If you're making $80,000 or more, you're not going to typically qualify for a Chapter 7 bankruptcy because of what we call the means test. But there's an exception, and the exception is if your non-consumer debt is greater than your consumer debt, you don't have to pass the means test. And what nobody knows out there is, and it's hard to even fathom or figure out the logic, tax debt is non-consumer debt. Your 1040 liability is non-consumer. So if you owe $200,000 in taxes and you only owe $100,000 on your mortgage, which is a non-consumer debt, you get a pass on the means test.
Is medical debt consumer debt?
That would be consumer debt.
Okay.
If you've signed a guarantee on a business loan and it's gone into default and they've sued you, that would be a business debt. If you use your credit cards for your business, it's business debt. If you use your credit cards for personal debt, it's consumer debt. So it's always a question of going through the analysis. But we just had a client who had $800,000 of income tax debt. So even though he was a high income earner, he had greater non-consumer debt than consumer debt. We planned this bankruptcy out over a 3-year period to capture all the years that he had the debt in. We filed the bankruptcy, discharged it all. Doesn't always work that easy, but it takes planning. Thanks for listening. Thanks for watching. We will be back next week with Law and Reality. Ian, thanks for joining us.
Thanks for having me. I really appreciate it.